Hi, my name is Rod Kight. I'm an attorney in Asheville, North Carolina, and I represent businesses in the cannabis industry. And on this blog post today, this video blog, I'm going to talk about a memo that was issued about an hour ago by Attorney General Jeff Sessions that involves the marijuana industry. And what I'm going to talk about in the next few minutes is just what the memo is, what it isn't, and maybe some things that we can be expected to happen in the wake of this memo. So first of all, I'd like to talk about what the memo is. The memo is simply a one-page document. This is actually the entire memo itself, issued from Jeff Sessions, the Attorney General. And what it does is withdraws prior memos by Attorney Generals in the Obama administration, most notably the Cole and Ogden memos. And in those memos, Attorney Generals Cole and Ogden said that while marijuana was in fact an illegal controlled substance under federal law, that the Justice Department was going to take its limited resources and use them elsewhere and not focus on prosecuting people in businesses involved in the marijuana industry unless they met certain criteria. For example, in the Cole memorandum, Attorney General Cole was concerned that possibly marijuana would be getting into the hands of youth, was concerned about mafia involvement, money laundering, transportation of marijuana from states where it was legalized into states where it wasn't. And when those types of things weren't triggered, the Cole memo said that federal prosecutors should use their discretion and not focus their limited resources on prosecuting those companies and individuals. And that's largely why we have had such a robust and rapidly evolving marijuana industry in the country, despite marijuana being federally illegal. And while it wasn't a change of the law, it helped a lot of companies and individuals feel better about investing their resources into the marijuana industry. Well, as many of you know, Attorney General Jeff Sessions is a big opponent of marijuana and marijuana reform in general, and today sort of sealed that. By withdrawing the prior memos, Jeff Sessions has opened things up for federal prosecutors to prosecute marijuana businesses even though they're operating lawfully under state law. So let's talk about what the memo does and what it doesn't do. So in the memo, fortunately, Jeff Sessions did not say that federal prosecutors should go after marijuana businesses. Attorney General Sessions is not, at least explicitly, saying that prosecutors should ramp up their enforcement efforts with respect to marijuana businesses. What Attorney General Sessions says is that these prior memos and this prioritization should be reconsidered. And there's a line in the memo that I think is important. What Jeff Sessions says is that these principles require federal prosecutors deciding which cases to prosecute to weigh all relevant considerations, including federal law enforcement priorities set by the Attorney General, the seriousness of the crime, the deterrent effect of criminal prosecution, and the cumulative impact of particular crimes on the community. So prosecutors are still given discretion, and certainly one can imagine that prosecutors in, say, Oakland, California, just to use an example off the top of my head, would be less inclined to prosecute than, say, a prosecutor in another state with brand new marijuana laws who maybe was opposed to them to begin with. And so, in short, the Sessions memo of today does not force prosecutors to go after marijuana businesses. However, it lifts any sort of prioritization scheme that they were under before today's memo. Let's talk about what it doesn't do. First of all, this memo does not affect medical states. Congress has enacted a widely known amendment, several consecutive amendments actually, that state that no federal funds can be used to prosecute state legal medical marijuana businesses or people who are compliant with their state's medical marijuana laws. So if you live in a state that has medical marijuana laws and you are compliant with those laws, then this memo does not apply to you. Federal funds prohibit the Justice Department from interfering, and in fact that's been held up or upheld in a couple of different court cases. Notably, this does not affect the hemp industry. The industrial hemp program is set forth in the 2014 Farm Act, and congressional funds have been set aside, or rather prevented from interfering with state legal hemp programs. And in fact, industrial hemp is not a controlled substance under the Controlled Substances Act. So it doesn't affect the hemp industry either. What this will impact potentially are people and businesses operating in what are now called recreational or adult use states. And as far as predictions, we don't really know yet where this is going to go. I think this is going to play out over the next several months. And so stay tuned for how this will impact the industry. One of the silver linings, and maybe at this stage the only silver lining, is that this may possibly be the thing that galvanizes Congress to finally change the law. So far, Congress has been able to sort of push this off because of the Cole Memos and say, well, we're not going to take a political risk and we're not going to change the law. And meanwhile, these industries in recreational states can continue to grow based on the Cole Memos. Well, now that those memos have been withdrawn, I'd like to see Congress step up and actually change the law. In fact, a majority of Americans, I think it's 60+% now, believe that marijuana should be available for adult use, and it's time for that to change. So thanks for listening and stay tuned.